Go.
Okay.
All right, let's do this. Welcome to our first podcast, Julie. All right, so today we've got Julie Fontagai from Rose Lawyers joining us, and we're going to talk about wills and estate planning. So what I know of Rose Lawyers has been around for about 43 years odd in Forest Hill, and you guys recently opened a branch in Moonee Ponds, and a generalist law firm. So just give us a little bit of background of what you guys do.
Yeah, so as mentioned, Rose Lawyers has been around for a very long time, predominantly in the Forest Hill area, but we're branching out to Moonee Ponds now. And so we're a journalist firm. Like mentioned, there's estate planning, there's wills, family, commercial. Yeah, so we do across the board range in legal matters. But what Rose Lawyers really stands for is that we want to provide solutions to our clients. We understand that legal matters can get very expensive very fast, and so we try to provide cost-effective solutions to our clients, but also empowering our clients in a sense where if we can provide any knowledge in assisting our client to mitigate that cost, then we can always bring it down and provide them other resources that our clients may not have known about prior to contacting our firm. So we always like empowering our clients to be able to do things themselves as well, and we can just guide them. That's how we mitigate and bring down costs, legal costs for our client.
Well, that's very exciting, man, because I understand how been through it a couple of times, how expensive it could be and stressful. Now, I'm a Moonee Valley man, so I'm very excited about the office in Moonee Ponds. That office will be fantastic. I'm very excited about it. But just to go on what we're going to talk about today is the need for wills and estate planning. And we've got quite a few questions that we would like answered. But the first question I ask is, well, why do I need a will? What's the purpose?
Yeah, so it's necessary to have a legally binding wills. I know that a lot of people, generally the younger generation, don't think it's very necessary to have a will, but accidents do happen, and we have seen cases where someone doesn't have a legally binding valid will, and so it becomes an issue when you need to administer the person's estate. So obviously a will comes into effect when the will maker passes, and so what the will does is that it outlines the manner that you want your estate to be distributed and who to look after your estate, so your executor and your trustee of your will. And like mentioned, in the case that you do not have it, the court will need to appoint an executor and trustee, and you may not want that person who the court appoints as a person looking after your estate. So we always recommend that, irrespective of your age and your circumstances, it's important to have a legally binding will so that your estates and wishes can be distributed according to your wishes.
So does it make it take longer if you don't have a will to get matters settled?
Yes, that's correct. So if you don't have a valid will, I'll kind of explain the process of when you do have a valid will first. So when you have a valid will and upon your passing, you have to, so the executor and trustee of your will obviously contact a firm, or they can do it themselves if it's not such a large estate. But generally we recommend that you do see a solicitor where they apply for grant of probate. So that goes to the Supreme Court. Supreme Court will grant the probate to the executor and trustee named in your will, and so then the solicitor that you've appointed to look after the estate can obviously look after the administration of your estate.
Right.
In the process, so in the process where there is no legally binding will, obviously it's a longer process because, as mentioned, you have to go through the court, and the court will have to determine who's fit and who's the most best person to look after your estate upon your passing. But like mentioned, it can take up to months longer if you don't have a legally binding will.
And I'm sure that's the last thing you want to be struggling with, after some loved one has passed away, to have to go through the process and uncertainty.
obviously it's a heightened emotional time, and obviously it's not something you want to be going through, to the court, getting documents together when obviously it's a difficult time when someone's passed that you care about. It's very hard to to think logically, especially when there's emotions involved. And so that's why with having a valid will, then that way it can eliminate some, at least some of those, tedious processes of going to court.
So it's important then. It's super important to get one.
Yes, that's right.
And so how do I go about making one? I see quite of these online will forms, which I'm quite dubious about. I'm quite nervous about those. How do I make a will? What do I have to do?
Look, obviously there are a lot of resources with obviously Google being available at the touch of a finger. There are a lot of resources where there's a lot of templates online, such as the Australia Will Kit. However, we at Rose Lawyers, we do recommend that you contact a solicitor to assist drafting up your will. It assures that that the solicitor incorporates everything, such as legislation wise, and to make sure that the clauses are prepared in a way where it prevents someone contesting, or at the same time you're able to attempt at drafting your own will, but it's best if you contact your solicitor to have a look through, and they'll know which clauses to include, what to exclude, and they'll know how to prepare it in a way where, like mentioned, if someone does choose to contest it, then it'll safeguard your will, to ensure that whoever chooses to contest it, then there's no discrepancy.
Yeah, because I agree. I think I can describe it in a way of, if I want to fly to Sydney, I'll jump on Webjet and book a quick flight. If I want to go on a world trip around the world, I'm going to get a travel agent to do it for me. That's the way I see it. It's just too many things involved, too many hotel bookings involved, too many things involved in between what can go wrong, and insurances and all that stuff. And we do a lot of marketing stuff, and we give away all our information. But it's like I said to our clients, if a mechanic can show me 50 times how to change the gearbox of my car, I'm just not going to do it, because I know there's stuff involved that I just will never know. And I think that's
professional assist in that. Yes, that's right, exactly. And like mentioned, with those kits and online forms, it's really very basic. It doesn't think of the processes of every person's circumstance. So for example, obviously every person making a will have different estates and want to distribute their estates differently and accordingly to their wishes. And so with a solicitor, they can assist in obviously distributing and putting clauses in relation to specific gifts. So we see a lot of people who have items such as expensive artwork or wedding rings. They want that to be specified and specific to a person, rather than just a very basic simple will saying whole of estate to person X, Y, Z. So with a solicitor, they can take on your personal circumstances, and distribute each gift to a specific person, rather than just making a very simple standard will.
So it's just as simple as booking an appointment with, say, for instance, yourself, going in, get all the information down. And how long does it normally take to make a will?
Yeah, so we generally give, at Rose Lawyers, a turnaround of about 3 to 4 weeks. So the process is that obviously we make contact with the client, we take instructions, but once we've taken the instructions, we go back and forth with the client, and it's fixed fee. So we take instructions back and forth with the client until they're satisfied and happy with how the will is presented. So, it can sometimes take up to sometimes 2 months, for example, if the client has quite a bit of asset pool, or if they've appointed an executor and trustee that's not currently in the state or that's overseas. And so it really depends on each matter. But generally our turnaround time, if it's a simple will, where we have all the information gathered, where there's only necessary for 2 or 3 appointments with the client, we give it around a 3 to 4 week turnaround.
That's fantastic. So now a real tricky question that get asked quite a lot is, how do I stop someone contesting a will? Because I think there's a lot of families that just don't talk to each other. There's money involved, and now all of a sudden the black sheep of the family didn't get anything and he or she wants to contest it. And so how do you stop someone from doing that? I get that question asked a lot.
No, definitely. We also do as well at Rose Lawyers. So you cannot legally stop someone from contesting a will. So that's very important to emphasize. Yeah. So what happens is that here at Rose Lawyers, we understand there might be a possibility of someone contesting will. For example, if you've been left, if you're a child of your parents and they've passed and you've realized your sister or brother is included in the will, but you're excluded. So we can understand there could be a bit of discrepancy there where someone contests that. However, when we draft our clients' wills, where there's obviously there's a chance someone could contest it, we add in extra clauses or letters of administration annexed to the will. So that way, if anybody or anyone wants to contest the will in court, there's an explanation of the will maker, like I said, with the annexed letters of administration and extra clauses within the will itself to pretty much safeguard your will, so that you can understand why the will maker has excluded a certain person. So, for example, like mentioned, if there's parents who passed and in their will they excluded one specific child and included another specific child, we do see this quite a bit. The letter of administration very concisely outlines their reasoning. And so if that child who was excluded from the will was to contest in court and wanted to contest the will, then obviously the parents would need to safeguard with extra clauses, like we said, and what the letter of administration pertains to. So it should all, that's why we do recommend that you do see a solicitor if it's a complicated will such as so, if you want to exclude or include certain people, is that the clauses and letters of administration we draft on the will maker's behalf can safeguard any possibility of contesting. I won't say that it can stop someone from contesting, because you can't stop someone, but generally the way we draft our clauses and letters of administration really does pertain to the will maker's wishes, in a sense that is very precise as to why they've drafted the will. The
parents just can actually protect their wishes, because they must have reasons, valid reasons for not to that child.
Exactly. And like I mentioned, with every certain person has different circumstances. So we've seen parents where they have 2 children and one is severely disabled or has some sort of medical condition that they obviously would like a larger percentage of their asset to go towards that child who will need ongoing care once they've passed. And so a larger percent of their asset will go towards child with a medical diagnosis, but we do also see that the other child can see it as being unfair and unjust. But as long as there's a letters of administration, extra clauses drafted within the will to explain why it was necessary and why the will maker has wishes for their larger estate to go towards the specific child, then it'll safeguard and make it a lot more difficult to
you can't do this in an online will. You can't protect yourself like this with an online will.
That's correct. No, you cannot. Like I said, you can attempt to draft your own will, but a solicitor will be able to word and add clauses in a will to safeguard it.
Yeah, I get it. Yeah, makes sense. So I know this is an open-ended question. It's probably quite difficult to answer, but how much does a will cost these days? What do you pay? Probably on
and so we do get a lot of inquiries about this as well, because I know that a lot of people will Google the average price of wool, and since you do see a will kit online or a template online for $200, $300, and it's very tempting to go with those. But look, like I mentioned, with Rose Lawyers, we're very cost effective. So for a simple drafted will, where you appoint 1, 2, or 3 executor and trustees, and like mentioned, if you want to add in extra gifts to specific beneficiaries, and you have just a few beneficiaries in mind, we draft your will for a price of between $440 and $660, and that's inclusive of GST. So that means no matter how many times we go back and forth with drafting, or how many clauses we add, we fix fee for that price. And so a lot of people have concerns about, and I know with any legal matter, whether it's wills or any other matter, sometimes fees can be a lot higher than expected. With Rose Lawyers, if anything changes, so we send over a disclosure statement and a cost agreement for you to view and sign before we start drafting your documents, so start drafting your will. And if anything was to change, we consult in you and let you know our price has either increased or decreased prior to proceeding. Okay. So for example, like mentioned, for a very simple one, once we've had our first consultation with you, the lawyers at Rose Lawyers will be able to tell you the price between $440 and $660. But if we find further that, for example, a testamentary trust will is better for you, then we will let you know prior to proceeding to do a very simple will, and let you know the further costs incurred.
Yeah. So again, online will just give you basics. I've had a discussion with someone the other day about it, and they go, well, I've got nothing to give to anyone, but I think your circumstances can change in the future. So get it right the first time, I think.
That's right. That's exactly. And while we're on the topic of that as well, so we do recommend as well that if your circumstances do change, for example, if you've been through a life-changing event such as a divorce with a spouse, if you do have an existing will that where your ex-spouse is to receive your whole estate, we do recommend that you update your will as soon as possible. So once the divorce has occurred and you've gone through the process of divorce, definitely get in contact with a solicitor to update your will to ensure that if anything was to happen to you in the time of divorce and passing, that your whole estate still doesn't go to your ex-spouse. So that's one thing we do recommend, and it's very important as well, because obviously with a will, if you've made one while you're married, your circumstances change drastically and who your beneficiaries are of your will. So get in contact with your solicitor. It doesn't have to be the person or the law firm that you've drafted your previous will with. You can go to another law firm and update it with any firm.
Interesting. So it could be something I can use against my kids misbehaving out of my will.
That's right. That's right.
Some leverage somewhere. I get older. I'm still
put them
iPads. That's not going to work for much longer.
That's right. That's right.
Oh, that's great. I mean, so let's have a quick chat about estate planning. What is estate planning? Can you just describe us what that involves?
Yeah. So with estate planning, it includes getting your affairs in order in the case that you pass away. So it's getting your affairs in order that includes financials, so your assets and properties, whether that be businesses, whether that be residential premises, investments, and so your children's affairs in order, and it also includes superannuation. So estate planning covers a whole wide range of those aspects, and there's lots of components to it. So people often think, let's just make a will and that will cover everything. And we generally often have to explain to clients that it doesn't, your will doesn't cover everything. So that's one thing we do with our clients as well, is when we get a phone call to say someone would like to draft a will, we actually question if they've done a whole estate planning. And people go, oh, what is estate planning? And like mentioned, it deals with all your finances, your property, anything towards children, affairs towards children, superannuation. So that includes documents such as your enduring power of attorney, which deals with personal or financial or both, and your appointment of medical treatment decision maker.
Okay, so estate planning is not the same as a will.
No, estate planning isn't the same as a will. So a will is one very, it's one very important component of estate planning, but like mentioned, estate planning does go further, and that often includes areas that are not covered in your will. So, for example, as mentioned before, your superannuation is part of your estate planning. A lot of people it is a part of your estate once you've passed, but with superannuation, even if you add a clause in your will pertaining to the superannuation, you actually have to legally nominate and bind a person within your superannuation separately. So when we do our estate planning, we also do question whether they've nominated someone for their superannuation. And a lot of people don't know this with the superannuation. They presume that if they make a will, it's included in their estate, it's part of an asset, so whoever receives the beneficiaries of the will receive the super as well. And no, it's not correct. So we advise, and obviously we can contact on the client's behalf and let them know the process of nominating someone through superannuation, who your beneficiary will be.
Oh, fantastic. All right. So do I need a lawyer to do estate planning? That's the question. Or can I do it myself?
Yeah. And like briefly,
well, obviously not, because I don't know much about it, but if someone does.
Yeah, no, look, it's the same answer that we mentioned in relation to the will. You can attempt to draft on your own as well, but at the same time, it's best to see a solicitor, because with the enduring power of attorney and the appointment of medical treatment decision maker, you need it to be signed by an authorized person. So a solicitor is an authorized person, and what they can do is they explain the document to you, and in the event of what will happen. So a lot of people have questions, oh, if this happens and X, Y, Z, what will happen to this and this, and who will do this, and who will look after this? And so obviously there's a lot of questions while you're drafting these documents, and a lawyer is the one who drafting your will and your estate planning will always be able to answer your questions for you and concerns you have. And so with the enduring power of attorney and the appointment of medical decision treatment maker, which documents a part of your estate planning, they need to explain to you what will happen. And obviously, once they've signed their witness certificate, they have to actually explain to you what will happen to your personal matters or your financial matters, and who looks after them in the case that you're incapable, or you're no longer able to make the decisions on your own.
Oh, well, I'm just thinking for myself, if something happens to me, which, well, because I'm going to get quite old. I think I've got another 60 years left. But if something happens, I just want everything to be smooth for my family, just to get things settled very quickly and efficiently. I think that's from my point of view, really important for me, just to get it done, get it all out, get all insurances paid, get all the money released, get everything paid off that needs to be done.
Exactly.
Get all the money to my favorite child, which is the important bit.
Which isn't one, it's all your children, your favorite children.
I've got a favorite.
Well, we won't say for the purposes.
No, nobody knows this. Nobody will know this. This is between me and you, okay?
That's a secret you take to your grave. No, definitely. Look, that's why we emphasize the importance of drafting your will and making legally binding will, and obviously getting your estate planning documents in order, because no one wants to go through all that while, you know, a loved one has passed away. So it's important documents to have, irrespective of, yeah, whether, like you said, whether you're old or young, whether you're fit, healthy, or anything can happen tomorrow. Unfortunately, that's life. Anything can really
And
happen.
how do you plan for it? How do you plan for your estate planning?
Yeah, so
How do you go about it?
so
The reason
generally
I'm
we
asking
just,
is, I just want, when we send this out, I want people to have practical solutions and, well, okay, what's the next step? It's like you explained the whole will thing really great. And that's why I'm asking, so how do I actually go do it? I know this sounds a little bit, just come see me, but what are people doing? What can they expect? Because we want to really get
yeah.
practical advice here for people.
Yeah, so with Rose Lawyers, we offer a 15-minute free consultation on the phone or in the office, but obviously not during these
Yeah.
times of COVID-19. But we offer a 15-minute free consultation where we go through the client, what's the best way forward of drafting your documents. You don't have to always make an appointment with your solicitor first. Sometimes we see clients coming from our in-house accountant or, you know, a financial advisor. They can refer you to us, and like mentioned, we have our 15-minute free consultation. So once we get the referral, we get on the phone or we meet with the client and we go through the importance of the documents and what to think about. So in our first consultation, whether the client moves forward with us or not, we say, look, it's important you think of who your executor and your trustee and who the beneficiaries are of your will, who you'd like to appoint as your first medical treatment decision maker, and who your appointed attorneys will be for your enduring power of attorney. And so we give them things to think about, and like I said, whether they're going to be clients or not, we give people information in order for them to be able to think about and to assist themselves in that way, whether they choose to come back to us. It's a very easy process of getting the details of their executor or trustees or their appointed attorneys. And so we start that process with clients even before they've agreed to move forward. Because what, like mentioned at Roselaw, is what we want to do is assist clients in their matters and moving forward. It's one of those things where with estate planning and wills, it's important for everyone to have. So we explain to them the process and the importance of it. And so it can really, it's a simple process if both parties cooperate and there's back and forth drafting and reviewing of documents.
Again, it just sounds to me like something you don't want to do by yourself. It just sounds way too risky. You know what I mean?
You definitely want to get it right. You definitely want to get it right. I mean, we've seen situations where there's a client where their mother had made a power of attorney, and so it wasn't a valid power of attorney, and so the mother was actually unfortunately very sick and ill in hospital, and they were trying to get her financial affairs in relation to their mother's property, and so the estate agent saw the power of attorney and it wasn't valid, and so the client had to call us and we quickly drafted, and like mentioned, even though it's a 3 to 4 week turnaround for a simple will in these, or estate planning, in these circumstances where clients are in a predicament where it's urgent and there's something that could possibly happen to their loved one in a very short amount of time, we can work around it. Obviously, we'll work tirelessly until the document is drafted and executed. The financial affairs and the wills and the estate planning can be in order. So with that client, it was a 4 to 5 day turnaround, and so we had one of our lawyers actually go out and meet the client in the hospital bed, and have this enduring power of attorney, financial attorney, executed, so that way it'd be valid. So when they did go and sell the property, then they could do it on their mother's behalf. And so it's one of those things that's very important to make sure you get it right, because in a situation like mentioned, when it's dire, you don't want to be messing with that. You want things to go as smoothly as possible. You don't want to be running around with solicitors and saying, oh no, look, my parents or my mother is about to pass away and she doesn't have these documents and I need to get things in order for her. So it just eliminates a lot of stress in an already stressful time.
Yeah, I think the beforehand stress is also, but I mean, if someone has passed away, the grief that you have to deal with, I don't think you want to go and deal with all that solicitors and deal with this and contested wills and this is not in process. You've got to go through the courts. You don't get probate, and it takes ages and ages for anything to settle. And you've got to pay all this stuff and grieve at the same time. So,
Exactly.
in short, get off, go and get your will done, plan your estate, do it now, and go do it with those lawyers. Is what I hear.
That's right. Do it for those lawyers. We can get it done for you.
Well, I know you're busy. Thank you for being our first guest ever on our podcast. I really appreciate your time and all the information you've given us. Go to roselaw.com.au. Visit their site, go have a chat with them if you've got any issues and other legal issues as well if you need to talk about. I know it's not just estate planning. You do conveyancing, if I'm correct, conveyancing, family law, and all other type of law. So go visit them. Roselaw.com.au. And thank you very much for your time. Really appreciate it, Julie.
No problems at all. Thanks for having me, Henry.
Thank you.
Thank you.